Get going here. Hi, I'm Roberta DiPietro, the Executive Director of the Greater Miami Festivals and Events Association. We were founded to support the success of festivals and events in the South Florida area. We would have normally had our one-day conference this time of year. Hopefully, we will see all of you next year when we meet in person for workshops, a vendor showcase, a performance showcase, networking, and happy hours. Instead, this year we decided to do a virtual mini conference, Navigating Rough Seas. Today is the last of our 5-part series of workshops and events, and this is the execution of contracts in the new normal. As we have a lot of attendees, we've turned off microphones and videos. If you do have a question, use the Q&A function at the bottom of your screen, and we will work through those questions either as we go or we'll save them till the end, depending on the relevancy. At this time, I'd like to turn it over to Attorney Ron Kuniak for our presentation. Good morning, Ron.
Good morning. Thank you for having me, and looking forward to talking with everybody about the execution of contracts in the new normal. And one of the things that I want to emphasize at the beginning is that execution of contracts in the new normal is mostly like execution of contracts in the old normal. And I'll explain that as we go through the program. So where we are. So it's been a little over 3 months since Rudy Gobert of the NBA tested positive. That resulted in the immediate suspension of the 2019-2020 NBA season that may restart soon, and also signaled the start of America's COVID-19 quarantine. So in the days that followed that, America and the world came to a halt. Pro sports were suspended. The NCAA basketball tournament was canceled. 2020 Olympics were postponed to 2021. Disney World closed, shelter-in-place rules and quarantine were imposed, work from home became the norm, and there's been massive unemployment. So where are we going? Things are the same but different. So unfortunately, but not unsurprisingly, businesses are suffering significant side effects from the bitter pill of our societal shutdown. Parties find themselves unable and sometimes unwilling to perform their obligations under a variety of agreements, including but not limited to mortgages, leases, service and sales contracts. So while the circumstances have changed due to COVID-19, the law has not. The same rules that applied before COVID-19 are equally applicable now. The question is how the facts apply to your current contractual situation and what concessions each side is willing and able to make in order to salvage or reform a transaction. So agreements in general. Legal agreements often seem complex to outsiders and non-attorneys. By looking at each provision, you can better understand how to structure terms to benefit you and your company and what rights and obligations you have under each agreement that your business is a party to. So agreements are living documents that need to be maintained and updated to keep pace with changes in the law, customized needs for your business, and circumstances. So business organizational documents. For your company, you're going to have documents that are buy-in between owners. The owners can be individuals or businesses. Examples are going to be operating agreements, shareholder agreements, or partnership agreements for whether it's an LLC, corporation, or partnership, and then joint venture agreements between your company and other businesses. These are going to be project-based deals that you may market under a different label, but each company is going to continue to maintain their separate identity and organization. All of these documents should be reviewed. A lot of the provisions that I'm going to go through apply to these, and then there are even more that are specific to your organizational documents, and you should have an attorney do an inventory. And that's what I suggest for everybody right now. Inventory your existing agreements. Identify the types of agreements your company is a party to. Some examples are going to be mortgage or lease for real property, contract for purchase or sale of real property or for goods and services, employment contracts, licensing, distribution, and more, joint ventures and strategic alliances, license agreements, user agreements, privacy policies. Identify parties to the agreements. The agreement should be buy-in between your company and the other party or parties. Never use your individual name in a contract, and I'll get to that. And then review key provisions of each agreement, term, fees to be paid or received, timelines, force majeure, and more. So COVID-19 implications. You need to conduct a special COVID-19 analysis to review the effect of the shutdown on your business operations and how present travel restrictions, group gathering restrictions, and essential or non-essential business rules are going to affect you. You need to explore the best ways to mitigate losses if performance is difficult or impossible. And you need to review enforcement and penalty provisions if you fear the other party will fail or refuse to perform. So parties to the, now I'm going to go through the various clauses and different issues with regard to agreements in general. So parties to the agreement. The most basic question to be addressed involves who is legally bound to the agreement. Any agreement should be signed by your company and the party with whom you are making a deal with, either an individual or their company. This is important for ensuring that you are protected from personal liability. I had a potential client call me a couple of weeks ago, even before COVID-19. They were having some business difficulties, and we looked at the contract, and she hadn't retained a lawyer, and she had a business that was set up, and she was operating the business from the space where she had a lease, but the lease was signed in her own personal name. And so the company had no liability under the agreement. She did. And the only way for her to get out of personal liability was bankruptcy. And it wasn't an option for her, and she's having difficulty because of it. You can generally only sue the party that signed the agreement. So that makes a big difference. Connected to this is looking at the asset base of the person or entity that's going to be bound by the agreement. Do they have assets? Will they have the ability to pay damages in event of default or dispute? Personal guarantee. So connected to this and which parties are bound is whether or not there's a personal guarantee, which provides that regardless of the protections of the corporate veil to the company that's a party to the contract, the owner might assume personal liability for all or part resulting from any default. Many contracting parties will want a personal guarantee from the other party to the agreement. You need to decide if you're willing to sign one and try to limit the time frame and enforce amount of the enforceability. And then you need to decide if you want to ask for one and what you're willing to accept from the other side if they push back. This provision has serious implication and requires careful consideration. And a lot of people are going to be unwilling to sign full personal guarantees going forward, given what they've experienced the last several months. Prevailing party provision. In Florida, each party to a lawsuit must usually bear their own attorney's fees and costs. There are two exceptions to this rule, where a plaintiff sues under a specific applicable Florida statute that provides for fees, and two, where attorney's fees are provided for in the agreement. An attorney's fee clause can prevent meritless lawsuits and will greatly aid in recovering what is lost by the prevailing party. This clause can directly save you thousands of dollars, so make sure it's included in any agreement you sign. Terms and conditions. This clause might seem obvious, and it should be obvious, but many business owners fail to specifically describe the terms of service, what is specifically required and not required of each party to the agreement, and the time frame for performance. Including what your business is not responsible for is essential for clarity and peace of mind in case of a lawsuit. A clear and unambiguous term of service section puts each party on notice of the exact requirements, leaving no room for ambiguity and limiting potential liability. Notice provision. A notice clause states how the parties to an agreement communicate with each other in written form. When communications are sent between parties, you don't want the other party to be able to claim that it wasn't received or that it wasn't received properly. This clause avoids that situation. Your notice clause can permit communications via email if you want. I like that, and should provide for a copy to be sent to your attorney. And when I draft agreements, I want that. Employment issues. You should consider having signed employment agreements with all types of employees, regardless of whether they are full-time, part-time employees, or independent contractors, especially if they're independent contractors. In addition, you should strongly consider having a written employment manual, which is distributed to all employees with a signed acknowledgement of receipt. In these circumstances, you may also want to prepare and distribute a return to work memo. outlining what steps you've taken to secure the workplace, what procedures you want employees to undertake when they are at the workplace, both in terms of being there in the first place and then interacting with customers, and then just general procedures in the office or workplace. Confidentiality, non-disclosure. Many commercial agreements contain one or more clauses on confidentiality. It's standard that you want to keep sensitive information among the parties without it leaking out to third parties not party to the agreement. It's important to consider the scope of the confidentiality provision. An overly broad provision may be an administrative burden, lead to unintended violations, and be difficult to enforce. A narrow provision may not protect the secrets for which it is intended to do so. You need to draft this carefully, go over what you're looking to protect, and figure out how to best do that. Non-compete, non-solicitation. Many agreements, particularly partnership and employment agreements, will call for non-competition and or non-solicitation clauses. The non-competition clause prevents a party from competing against the other using the information from their prior relationship for some period of time. The non-solicitation clause typically prevents one party from taking the employees, customers, or other commercial relationships of the other party for some period of time. Both are generally important clauses to include in an agreement, and both have a lot of commercial protection for the parties, but it's important to carefully tailor these provisions to be meaningful and enforceable, both in terms of time frame and geography. You can't prevent someone from earning a living. So you can't say, no, you can't work in the entire state of Florida, or you can't work in the entire continental United States. It has to be a specific geographic area. And the larger the geographic area and the larger the time frame, the less it's going to be enforceable. And the larger the geographic area, the shorter the time frame. The larger the time frame, the smaller the geographic area is going to need to be. Contractual authority. You want to make sure that the businesses and the individuals signing on behalf of those businesses have authority to enter into the agreement, and that the agreement will not violate unrelated agreements that those parties have with others. So you want to get a corporate resolution as an attachment to any significant agreement to provide protection to show that they had authority. Moreover, if party A and party B are entering into agreement, it's not uncommon for party B to want to be sure that party A is not violating an agreement with party C, who might sue party B for breach of that agreement and might sue party A for interference with it. So you want to get a written authorization that the deal that you're making won't do this. Assignment and subletting. So often there's a personal relationship between the parties to an agreement. This is often the case in a residential landlord-tenant relationship where the landlord has conducted a background check on the particular tenant with whom they are renting the property to, but it's often the case with commercial relationships as well. As a general rule, most agreements provide that the agreement cannot be assigned to the third party without consent of the other party. This is a bar to subletting without the landlord's consent in real estate matters. Such drafting is neutral and protects both parties from that eventuality. However, it would not be unusual to seek a one-way obligation to seek consent to assign if the party seeking to impose that obligation on the other party has concerns as to who might end up occupying the party or providing it with services and products. If I make a deal, and this is for any deal, if I make a deal with a marketing company to provide my marketing, I don't want them to assign it to a different marketing company that I don't have a relationship with. Or if I contract with a lawyer, I don't want him to assign the contract. Or so there are various reasons not to allow assignment of deals. Merger integration clause. In most agreements, you'll find a merger integration clause, which provides that all prior agreements among the parties are brought together in the written agreement. This is usually desirable because we want a contract that is complete and is the only document governing the relationship among the parties for that particular item. One thing to be aware of is that if you're doing a contract for one set of services and then you enter into a contract for another set of services, you may want to be careful that the integration clause in the second contract doesn't void anything in the first contract. Severability clause. So a severability clause upholds the sanctity of an entire agreement, even where the court finds one clause to be illusory, unconscionable, or otherwise unlawful. Your agreement should be designed to give you the upper hand in case of any litigation, and many parties have lost their case because they failed to include a severability clause in their contract. It's a simple addition that can make all the difference during a legal dispute. Dispute resolution provisions. Usually buried towards the end of the agreement is the dispute resolution provision, which provides for the procedure if you end up in a dispute with the other party: mediation, arbitration, and/or litigation. Mediation is usually voluntary, even if it's not provided for in the agreement. If you go to litigation, it's probably going to be one of the first things that a judge orders the parties to do. Arbitration is a mandatory form of mediation where the arbitrator makes a decision in lieu of going to court. Forum selection venue provision. So especially when dealing with out-of-state customers, contractors, or suppliers, being the home party in any lawsuit has a great cost advantage. So your agreement should clearly indicate that upon any dispute over its contents, venue is proper in the state of Florida and in your specific county, Miami-Dade, Broward, Palm Beach, or elsewhere. If you're viewing this from another state, then obviously venue should be proper in the state and county where your business resides. And then again, if you're here in Florida, you want Florida law to govern your dispute. And if you are elsewhere, then you want other law to govern. Indemnification. An indemnification clause shifts risk from one party to another. It often kicks in when one party to the agreement violates the rights of another person or entity, typically a non-party to the agreement. For instance, if both party A and party B sign an agreement and party A violates the rights of party C, the indemnification clause, and I apologize for the typo, will allow party B to seek compensation from party A if party B is sued by party C. No partnership or agency. Agreements frequently contain boilerplate provisions stating that the relationship between the parties is not to be construed as a partnership or agency. This is because both of those legal forms may arise implicitly without the parties realizing that they have done so, and both have a range of legal and tax implications for the parties. If the parties do not intend for them to arise, it may be safer to state expressly that the contract does not create either form of relationship to ensure that no unintended consequences flow from the agreement. Termination and damages. Savvy business owners will include an early termination and damages clause in their agreements. This clause gives business owners an out just in case performance under the agreement becomes either impossible or financially detrimental to the business. The termination clause can be tricky to create and must be properly drafted, and should also state specific damages, if applicable, that each party is entitled to in the case of early termination. Limiting your damages in case of breach can be a make or break difference in the viability of your business. Event of default. So the phrase default or event of default is a fixture primarily in loan agreements and real property leases where one or more occurrences give the lender or landlord the opportunity to terminate the agreement. So examples include failure to pay, failure to comply with terms of agreement, and or bankruptcy and insolvency of the company, and sometimes one or more principals of the company. And there could be other events of default as well. Waiver. In the absence of a waiver clause where a party fails to take action in respect of a breach or default under the agreement or delays in taking action, the party may lose its rights to take action later based on that default. So a waiver clause is designed to ensure that if you're asleep at the wheel or lazy or trying to negotiate to fix the problem while there's a waiver, that the remedy won't be lost and that the delay or omission in enforcing your rights under the agreement won't be waived. Force majeure, and this is, an issue everybody's talking about these days. Force majeure is a common clause in agreements that essentially frees both parties from liability or obligation when an extraordinary event or circumstance beyond the control of the parties, such as an act of God, act of nature, or national emergency, prevents one or both parties from fulfilling their obligations under the agreement. So in practice, most force majeure clauses do not excuse a party's non-performance entirely, but only suspend it for the duration of the force majeure. And more importantly, this clause is in there as a, I hate to say, it was previously designed as a potential what if, and really was more for active nature. It was more for hurricanes and tornadoes and earthquakes and fires. I don't think this was really drafted understanding what might happen with a global pandemic like COVID-19. This is going to be a heavily litigated topic, and most of the attorneys that I've spoken to are using it as a litigation tactic to promote negotiation between the parties and figure out how to fix the deal going forward rather than to entirely void it. So refund requests and chargebacks. It's critical that you implement a strategy for dealing with refund requests and avoiding, reducing, and disputing chargebacks. This will help ensure positive interactions with your customers and will put you in position to recover disputed revenue and prevent future chargebacks, making a winning chargeback strategy an investment that will continue to pay off long after things return to normal. The real problem here is that, most people, when you're a landlord and you get I apologize, I'm totally blanking. When you get a deposit from your tenant, a residential landlord has to put that in a special account. And if they don't put that into an account for the benefit of the tenant later at the end of the lease, then they lose rights to use it. When you're running a business, oftentimes when you take deposits, you're not necessarily segregating them and not accessing that money until the good or service is utilized. So you may have spent people's deposits, and that's a huge problem when people are asking for refund requests. So some suggestions on refund requests and chargebacks: use multi-level fraud detection systems, optimize your response, deploy smarter chatbots on your website, adhere to best practices with credit card companies and merchant services, make cancellations easy when possible, and offer alternatives. Roll over registration to future events, redirect fees to other programs and benefits, offer optional donations, whether it's to your company or to charities. So bankruptcy overview. Bankruptcy could be the subject of an entirely separate webinar. The US Constitution gives Congress the authority to enact bankruptcy laws for the entire country. The current law is the Bankruptcy Reform Act of 1978, codified in Title 11 of the US Code, the Bankruptcy Code. There were major changes in 2005 when Congress enacted the Bankruptcy Abuse Prevention and Consumer Protection Act, BAPS-CPA. Recent changes include the Small Business Reorganization Act of 2019, and then technical fixes that were included within the CARES Act. So the Bankruptcy Code in general. Chapters 1, 3, and 5 are procedural. Chapter 1 is definitions. Chapter 3 is case administration. Chapter 5 covers matters related to rights of debtors and creditors. Chapters 7, 9, 11, 12, 13, and 15 are substantive. Chapter 7 governs personal liquidation. Chapter 9 for municipal bankruptcies, but not state bankruptcies. Chapter 11 for corporate reorganization, and there are new provisions for a small business bankruptcy that'll make it easier for businesses to file and reorganize. Chapter 12 governs family farmers. Chapter 13 is individual debt adjustment, and if individuals have higher asset and debt figures than allowed, then they can file a personal Chapter 11. And then Chapter 15 governs ancillary and cross-border insolvency matters. So why is this relevant in the discussion of contracts? Because in bankruptcy, debtors have very specific powers related to contracts. So first is, and to what goes on in litigation surrounding them. The first thing is that when you file for bankruptcy, there's an automatic stay on any and all litigation and collection efforts against the debtor. So if a business is hemorrhaging money, is being sued by their bank, their landlord, their vendors, their customers, automatic stay stops all of that, puts a halt to it, and says you have to come into bankruptcy court where all the creditors can be treated fairly and equally, not necessarily equally in terms of their returns from the debtor, but equally in terms of where they are in the time frame of their litigation. Rejection of leases and contracts. The Bankruptcy Code gives debtors the power to reject leases and executory contracts, thereby reducing obligations on a going forward basis and giving debtors a stronger hand in negotiating with landlords and vendors. If you have contracts that are just untenable because of COVID-19, bankruptcy may just be the best option to reject those leases and contracts and pay a smaller amount in damages than what would ordinarily be required under the contract or agreement. And then DIP financing, debtor in possession financing. Debtors can obtain special financing from lenders who can obtain priority over other creditors. And this allows you to have some cash flow when you otherwise might not be able to get any. So just a quick note about residential mortgages and evictions. Residential mortgage foreclosures and landlord-tenant evictions have been suspended statewide until July 1, 2020. There have been multiple extensions of this deadline, and it's possible it may be extended again. This is a state-mandated change to any existing mortgage or lease agreement. These rules do not apply to commercial properties. I've had tens of potential clients call me over the last couple of weeks. Well, I can't be evicted from my commercial property if I don't pay rent to the landlord. And that's not true. You can be evicted. The landlord may not seek to evict right now because they don't want to be the one in court being the bad guy, but eventually they're going to bring eviction actions. Concluding thoughts. Despite the significant changes to our lives due to COVID-19, many of the issues affecting businesses and business owners remain unchanged. The law is the same, it's just how it applies. Successful businesses have complete and accurate records, especially as it relates to business agreements with other parties. You need to identify, organize, and inventory your business records now if you have not ever done so. Consulting with professionals can save you time and money. And that is my presentation. And
Thank you,
I'm happy to answer questions.
We have questions.
Okay.
Our first one is, what about deposits taken for work that's been postponed or canceled as a vendor? Like, I've done some work against that deposit. What clause or language should we put in a contract in case of cancellation on their part?
Well, a couple of things. First, you want to provide that deposits are non-refundable. And then you want to be able to tweak that for each individual situation. You may need to refund a deposit. Secondly, when you're doing work against a deposit, and this depends on whether you're billing flat fee or hourly, you should be able to provide that in the event of a cancellation or a dispute, that you can, charge against the deposit for the work that's been done. So a lot of times, even when I do flat fee work, I keep my time. So I know, so I can evaluate whether I've done, an appropriate flat fee, but also, whether there's, an ability to charge against that if I need to refund some of that. So I hope that answers the question. And then,
okay, we have our next question. Yeah. How would a severability clause work in the event industry, say, like if you contract a performer?
A severability clause is going to work the same regardless of the type of contract it is. What a severability clause says is that if a particular clause in a contract is deemed to be improper or unenforceable, the rest of the contract is still viable. So what it says is, if you have a venue provision, I'm going to use the ones that are sort of nondescript. If you have a venue provision and you say venues in Florida and Palm Beach County and Florida law applies, and for some reason, and the other party resides elsewhere, and there's an ability to transfer the case to federal court or to the state court where they are, and there are provisions that provision shouldn't apply, you don't want that venue provision to let the other party out of the entire contract.
Oh, okay.
So that's what a severability clause does. It's not going to be specific to a performer. It's going to be with regard to any contract that you have.
Okay. Our next question, I think this is like an organization contracting with vendors or performers. How do you handle the payment part of the contract if the event is canceled? I assume they mean if you've agreed on a payment amount and then you cancel the event.
Again, you need to have a provision in there that that you can cancel under certain circumstances, and what happens, in that event to, liabilities by the parties. That's really going to be partly the force majeure clause.
Right.
But, you can edit that and add other clauses. And it goes both ways. Like, what happens if the performer, exclude COVID-19? What if the performer, what if the plane, they're traveling from another state and their flight is canceled, they're unable to get to the event, or if they, get the flu or, or food poisoning and they're not able to perform. So those provisions are going to go both ways, and you want to have contingency plans on how to deal with it.
Okay. Okay, the next one is, will we get a recording of the presentation? Yes, we will. It'll be posted on our website. And
thank you for the compliment, because I can read I have the questions in front of me too.
yes.
So what's the best form of bankruptcy when trying to protect assets? Well, let's back up. If you're filing your business and you want the business to continue going forward, then you have to file a Chapter 11. That's the reorganization chapter for businesses. If you're an individual, you want to see what the best situation is for you. Chapter 7 will give you a full discharge of your liability, but you have to surrender non-exempt assets to a trustee. Chapter 13 lets you keep assets and make payments over time. You don't get a discharge till you've made those payments. So the best form of bankruptcy is going to be dependent on your circumstances. And I'm happy, I do bankruptcy law, and I'm happy to do a free consult with you on that topic and discuss bankruptcy planning or your options. As for the stigma of bankruptcy, I think that is going to go away in whole or in part in this time period we're in. Everybody understands that the circumstances surrounding COVID-19 are out of anybody's control. Nobody's blaming people except those people who completely are disregarding, health guidelines. Nobody, and even then, nobody's saying you deserve COVID, but certainly nobody's saying that you deserve to lose your business or your livelihood or your home over COVID. And everybody understands that no one was prepared for this type of situation. So I think the stigma issue is going to go away. The other piece is, and I've been practicing bankruptcy for 25 years, and I've said this for 25 years. If you need to file bankruptcy, you need to file bankruptcy. Stigma be damned. Bankruptcy is the law of the land. The president's filed for bankruptcy. The president's filed his companies for bankruptcy. He was elected president, notwithstanding having filed multiple companies for bankruptcy. I think the stigma of bankruptcy issue is overrated. It's more of a personal, internal embarrassment or shame that my clients have all the time when they come to me to talk about their financial issues. They don't want to, even with a stranger, they don't want to share it. They certainly don't want to share it with neighbors and friends, which is why I get most of my referrals on bankruptcy from strangers rather than friends, because you don't talk about it with people. You don't talk about your income or your expenses or how you feel overwhelmed by those things, but you do. And so if you're feeling those things or you're worried about those things, then please don't hesitate to call me.
Okay. Our next question, can you give examples of termination / damages?
It's really going to be business specific. So it depends on what type of goods and services you're providing, and how that impacts the party you're contracting with, and what everybody's willing to accept in terms of, termination and damages. The easier way to explain it is in a residential real estate purchase and sale contract. If the agreement is terminated before the closing, oftentimes there'll be a provision that the buyer forfeits the deposit. And the deposit is normally 10% of the purchase price. That's how it's done generally in a residential real estate contract. In a business contract, you're going to need to find the sweet spot of what you're willing to accept if the deal isn't completed, and what the other party is willing to give you if they're unable to complete the deal. And on top of that, you need to have, some sort of assurances that you're going to be able to collect those damages.
Okay. Our next question, should it be listed as non-refundable deposit or retainer, or does it matter?
If you can, you should. You should make it as non-refundable as possible. Depending on how big or small the the deposit is, they may sue anyway, and they may want it anyway. And depending on how many deposits you have, whether they're one-off or whether it's an event, then you may need to talk about it. My kids were supposed to go to summer camp this summer. There were 500 kids at the camp. Everybody's been making payments on a payment plan from last summer till now to pay the tuition for summer camp, and sleepaway camp was canceled. And now the camp owners are faced with how do we refund this camp tuition, and how do we do this so that we maintain this relationship with these parents, so that they want to send their kids back next summer, so they want to send more of their kids, etc. So my camp offered to froze tuition for next summer for everybody who was registered for this summer, rolled over tuition for next summer so that the deposits apply and there's no further money owed if you were paid in full. And if you weren't paid in full, you only owe the balance between what you had already paid and what you stopped when you stopped paying, when this COVID started and you sort of thought you weren't going to have camp this summer. And if your kids are at the age where they've graduated out and they don't want to come next summer, then they're offering refunds. But they've said we'll give you refunds between now and next summer as our cash becomes available, because they've spent some of that, and everybody who's involved in the camp understands that they've spent some of that in preparation for this summer, renovating cabins, improving amenities, adding activities for the kids, etc. So sometimes it's not as easy to refund the deposit immediately, even if you have to. So that's what I would say about that.
Okay, our next question, residential mortgages and evictions. Once the suspension is lifted, will the tenants, homeowners be required to pay for the months they were exempt from eviction?
Generally, yes. There was no suspension on the obligation to pay. It was a suspension on the ability to foreclose or evict. Those monies are going to become due. Sometimes they're being put on the back of the loan or the lease, so that things are being extended additional months, and they're getting, for all intents and purposes, several months free. Other times they're not being extended. They're not being put on the back end for leases. That wasn't anything that was being forced on individual landlords. The question becomes, how quickly can you evict, and how quickly can you get a new tenant in the space? And are there better options in terms of negotiating with that particular tenant to get some money now and get them to pay you back later? Again, a lot of those tenants I expect to be my individual Chapter 13 clients on the eve of eviction, where I can take the money that's owed pre-petition under the lease and have the tenant pay that over a 3 or 5 year period, so long as they resume making regular payments. So it's another reason why bankruptcy may be an option for a lot of people.
Okay, our next question. Can you discuss severability again?
I'm happy to do it. I'm just not sure what the misunderstanding is.
I guess maybe
what it means. I'm going to try and then ask again if I'm not responding to it, Bobby. I apologize. A contract is a series of clauses. I went through a host of those clauses in my presentation. Any one of those clauses, if there's a lawsuit, and only in the event of a lawsuit, an affirmative defense to the enforceability of the agreement is going to be that one or more particular clauses are unenforceable, thereby making the whole agreement null and void. A severability clause says that even if the defendant is successful in arguing that a particular clause is unlawful and inapplicable and unenforceable, that the remainder of the deal doesn't get stricken as a matter of law. So that's what the severability clause is. If I'm not answering it, ask it again. If I'm not answering it, feel free to call me and I'll go over it with you privately.
Okay, thank you. Are there specific clauses to assist with contracting artists who are now performing virtual performances?
Again, it's going to be the same sort of contracts, whether your event is taking place live in person or online. You're going to have similar contract. You're going to have the same sort of contract. There's going to be not a whole lot else. The only issue that I would see potentially is that people are going to have to take responsibility for their own internet connection, so that you can't be responsible if they can't log on. If it's a problem on your end, you're going to be liable. But if it's a problem, if they have Comcast and Comcast has an outage in their area the day of the event, you're not going to be responsible for their inability to get online and log in to view the virtual performance. My daughter is a dancer. She goes to a dance studio. The dance studio has been doing their classes online since March. We didn't sign any additional agreements. They just said we're switching to virtual classes. The teacher will appear on the computer screen, and she'll watch in Zoom the individual dancers perform and critique them. So that's how that's been going forward.
Okay, thank you. If you say a deposit is non-refundable, would that be viable in every circumstance?
Nothing is viable in every circumstance. So, and saying a deposit is non-refundable doesn't make it so. It just makes it so that you can claim that it's non-refundable. And then you can fight over the amount of the deposit, the amount that'll be refundable, or the circumstances under which you might be willing to refund it. And what it's protection against is that if you have 10 deposits, you have 100 deposits, and you say that the deposit is non-refundable, hopefully 9 out of 10, 7 out of 10, 90 out of 100, 70 out of 100 don't even come to you and ask for a deposit. And therefore you're only dealing with 1 or 2 or 10 or 20, depending on the volume of deposits. And if you do the math on that, then from the deposits that nobody's asking for refunds on, you can actually fund the deposits that people are asking for.
Okay. The next question is, what is the reschedule window as it relates to force majeure clause with the current uncertainty? Regular agreements allow for rescheduling in a year in good faith, but what can be written into a contract to give more room for good faith negotiations without losses on either side?
You can negotiate anything that the parties are willing to agree to. And you can negotiate it before, when you're entering into the contract, or you can negotiate it after, like now, when you're trying to modify the contract. The best example I can give you is right now the pro sports negotiations. So the NBA has a force majeure clause in their contract that allows them to cancel the season, cancel the collective bargaining agreement, and cancel the current contracts with the players. That is a heavy, heavy hammer that the NBA has. And the NBA has not used it. what the NBA has done is kick the can on the deadline for them to exercise that clause. Originally, it was June, then it was July, now it's September. And with the extension of the deadline for them to exercise or waive the force majeure clause, they are negotiating with the players on how they try to go back to work, how they resume the season and have the playoffs, and what they do for next season, and how they deal with the salary cap. Baseball doesn't have a force majeure clause, and the baseball players and the owners are having a bitter fight, and they already renegotiated. They negotiated a pro rata payment. They negotiated a flat amount that the players would be given as an advance on the regular season. They did this in April and May, that they would get $130 million, that it was non-refundable, and that it would be applied to if and when they went to the regular season. And if they went to the regular season, they would be paid, for the amount of games, and et cetera, et cetera. And now they're fighting over the number of games, because the owners have figured out that the $130 million translates to 50 games, and they want to pay for only 50 games. So they want them to play 80 games but get paid for 50. And the players are saying, we agreed to take this, but you can't negotiate the number of games. And they're fighting over the number of games. They're fighting over this, when the season starts. They're fighting over how they go forward. So you can negotiate it. The question is what leverage you have in your negotiations, and then what circumstances are. Right now, you can't reschedule anything. And if you can, you're rescheduling on a hope and a prayer that you can do it in December or January or February. And you may need to have a provision that if you're not allowed to do it, that you could, either cancel or reschedule for another time. And again, the other party has to be available as well. Nobody expected any of this. I know, I keep going back to personal experience because it's the best way I find to explain a complex situation. So I have 16, 14, and 11-year-old kids. They all have sweet 16s and bar and bat mitzvahs. You contract with venues and bands, and DJs and caterers. Nobody expected to not be able to do these events and not know when they could reschedule these events for. So, a lot of times, people are being flexible with it. Hold on to the deposit. We'll talk to you when we can do the event again. They want to do the event. They want to do the party for their kid. They can't do it right now. So that's what's going on. But on the flip side, I saw a horrible story a couple of weeks ago. A groom had a deposit with a photographer for a wedding, and the fiance was killed in a car accident. And he asked for a refund, and the photographer said, "No, I'm not giving you a refund. I'll apply it to your next engagement, to your next wedding when you meet someone else to marry." And he was like, "That's the most horrible thing in the world to say to someone who lost their fiance." And he went on all the review sites and gave bad reviews. Like, there are ways to deal with your customers, and that. And so a lot of this is common sense and best practices, and everybody trying to be flexible under what is unimaginable circumstances. So I hope that answered the question.
Okay, thank you. I'm not sure I understand the next question.
I think it's a two-part. I think is it legally binding to have the following included in your contract? And then it's the deposit may be applied to rescheduling the event for a future date, but not to exceed 6 months from the original scheduled date. Yeah, you can put that in a contract. The problem becomes, if 6 months from now we're in the same situation we're in, or if if they reschedule and then you have a second wave and it reoccurs. But whatever people are willing to agree to is acceptable. If someone is willing, if you have a provision that says, if you're silent on the deposit and you're trying to negotiate what to do with the deposit, and you offer them to apply it to another event rescheduled, and they're willing to do that, you can do that. If you have a provision that it's non-refundable, and they ask for it to be refunded anyway. And you say, well, I can't refund it, but I'll apply it to a future event, and they're willing to do that, then that's great. Let me make one global comment for all of these things. If you have, first, anything you have should be in writing for the contracts that you already have. And then any changes to the contracts that you have ought to be in writing as well. Don't rely on emails. Don't rely on a series of emails that may be misinterpreted. Write it out, put the clause, get everybody to sign it, say it's applicable to the deal.
Okay. Our next question, what happens if you already postponed a scheduled corporate event to next year, but the event is still unable to be held due to COVID-19? You've already collected 90% of the money from the client, paid non-refundable deposits to your vendors, and have done all of the upfront work when the event was canceled about 1 month before the scheduled date.
So part of it's going to depend on what the cancellation provisions are in the contract. Part of it's going to be whether the contract provides that the money from the client is non-refundable. Part of it's going to be whether you can get any of the deposits paid to your vendors back, even though they're non-refundable. And then part of it's going to be how you're able to work with everybody. Can you reschedule it again? Do they just want to cancel it and get their money back? And again, this is going to be one of those scenarios where, bankruptcy might be the better option, where you can say, okay, I owe you this money. You're an unsecured creditor, and I'm going to pay unsecured creditors, 20 cents on the dollar, 30 cents on the dollar in a plan of reorganization. Or I'm going to do the event or refund the money 100%, but I'm going to refund it over 5 years. Those are going to be, the scenarios. And, I beg you to call me or another lawyer and review all of the contingencies, all of the related contracts, all of where the money is and could be, recouped. So in a bankruptcy too, even though things are non-refundable, you can claw back some of those monies from vendors. So, it might be, I'm going to file for bankruptcy. I'm going to have to sue these vendors to recover the money I've paid them. And I'm going to use that money to pay my, creditors, my clients in the plan. It's not pretty. It's not happy. I understand that you want to make your clients happy and your vendors happy because you want to use your vendors for other events in the future. But, these are strange circumstances and uncharted waters, and we have to be flexible and move forward.
Okay, next question. If someone was to host an event at the current moment, is there a way to protect yourself from a lawsuit if your organization hosts an event? For example, a city hosts an outdoor event. If they have signage stating to wear masks and have hand sanitizer stations and temperature checks, would those measures protect from being sued in the event of someone contracting COVID-19?
So first, I don't think any cities are hosting outdoor events right now. And if I'm incorrect, correct me. But I can't imagine any city hosting an event or giving a permit for an event right now. And, there are, everybody's got, rules on the number of people allowed into a venue. I shouldn't say nobody's allowing it because there's going to be a political rally in Oklahoma for 19,000 people in an indoor arena. So the issue is who's hosting the event. And if it's a municipality, they have their own, separate provisions on how you sue and how whether you're able to sue them or not, and for what amounts and how you go about doing that. But if you're an event organizer and you're hosting, you know, a larger event, or you're hosting any kind of event, or you're you know, you want to take as many safety procedures as possible: masks, hand sanitizers, temperature checks. You want to distribute information about those procedures, and you want to get written signed waivers from everybody. The extent and applicability of the waiver is going to be, you know, something that's litigated if someone contracts COVID-19 and is able to prove they got it. And then they're going to have to prove where they got it. You know, if they were going to one event, were they going to multiple events? If they went to one restaurant for dinner, were they going to multiple restaurants for dinners over, you know, a course of a period of time? It's not going to be as easy as possible. It's not going to be as easy as people think it is to prove causation and damages. So I think there's going to be a lot less you gave me COVID litigation than people are talking about. But it's going to be there. And it's going to be an issue that people need to try and, you know, gauge what their willingness is for what level of risk and reward.
Okay, our next question is, what happens if you don't have all these things in your contract and all your events were canceled due to COVID? Is the vendor or the event responsible, or does it depend?
It depends. And I'm going to give my call a lawyer speech one more time. You can't bury your head in the sand on it. If you have a contract and the contract isn't going forward, and you are either liable under the contract or you have damages resulting from it, call an attorney. Feel free to call me, but please call somebody.
Okay, what happens if an entertainment vendor has received a 50% deposit earlier this year for a large event in August, which is now canceled due to COVID and rescheduled to next year? Should the deposits be applied to the new dates in 2021? What if the vendor is already booked elsewhere for the new dates and therefore unavailable?
So the first question is, what are the provisions of the contract? Does it provide that the deposit to the vendor is non-refundable? Even if it's non-refundable, is the vendor ready, willing, able, willing to refund the deposit? Should it be applied? In good faith, probably, but the contract will govern that. If the vendor is booked elsewhere, then, you know, they ought to probably refund the deposit and tell them to go get a different entertainer, you know, and you've already gotten a different deposit. So, you know, potentially you've been made whole for, you know, able to borrow from Peter to pay Paul, to take one deposit to refund the other deposit. But again, you have to look at your contracts, see what the provisions are, and then see, you know, in good faith, what you're willing to negotiate.
Okay, thank you. More on virtual performances. What are the clauses to consider regarding proprietary of the recorded virtual content? Payments to artists for how often the content is sold or viewed? What else should be considered?
Those are great questions. And the answer is all of them. So you want to have a provision that provides who owns the recording and how the recording is able to be used, and whether it was a one-time, whether it can be recorded or not, whether the entertainer is being paid a flat fee for the performance, or whether they're being paid based on views and tickets sold, and how and in what manner, and whether it's able to be downloaded or just viewed as a one-time viewing. Those are all going to be valid considerations that you ought to have in your contract. And the answer is, the other part of it is, how should it be structured? It should be structured however you and the performer are willing to structure it, and what you want to do.
Okay, our next question. Where is the best place to find a COVID waiver to issue to event participants?
From your lawyer. I don't mean to be flippant on that, but all you could Google all of these things.
Right.
And you could Google any of the topics, any of the particular clauses that I've discussed today, or any other clauses that I haven't discussed, like the payments for virtual performances that was just asked. You could find examples of any of that online. You can find it from, online legal providers that let you fill in the blanks and pay for a form. What you're not going to get, not to toot my own horn, but I really mean this as to every lawyer, you're not going to get the analysis of the specificity of your situation, and you need that, and it's important to do that, and to not do that is penny wise and pound foolish. Not to give a complete plug, but I offer flat fee billing for my corporate clients, where I do an inventory of their current contracts. I tell them what the problems are in those agreements. We map out what their business plan is for the year. I'm available on call by phone and email without additional charge. I charge a flat fee for that. There's a benefit, whether you're paying me a flat fee, or whether you're paying me an hourly fee, or whether you're paying another attorney an hourly fee. There you get our knowledge and experience and our ability to tweak forms for your benefit. So yeah, you can Google COVID waiver and find a host of forms, but it's worth the amount you spent on it.
And that's the end of our questions. I want to thank you, Ron. And I do want to mention again that you did offer an hour free consultation to any of our viewers today.
Yeah.
All right,
Yeah.
we will be sending out the information on how to contact Ron if you want to take advantage of that hour of free consultation.
You can call me at 561-292-2127. And easier to spell than my law firm name is my website, kaniuklawoffice.com. But I've also got a website, coviddebtproblems.com, and there's a scheduling feature on there that you can schedule an appointment with me.
That's
and if
great.
you want to schedule a longer appointment than is provided for, then just call me and I'll be happy to do it.
Well, we thank you so much. You've been very instrumental in our mini conference here with your 2 workshops on legal advice, and this is the last of the 5-part of our mini conference. We've enjoyed having all of you all the way through. We look forward to providing support as the Greater Miami Festivals and Events Association does for everyone that is in this industry. We know it's a hard time for everyone. We will continue to keep up with things that are happening and share that with you. And we want to thank you for joining us. If you've joined us for one or all or any of our workshops these past 2 weeks, we've certainly enjoyed having you all. And thank you, Ron. And everyone stay safe. Have a great day. Any questions, you can email us at info@festivalsmiami.com.
Thank you very much, Roberta. And really my last best piece of advice is call an attorney. Rely on professionals. It's not just an attorney, an accountant, your insurance broker, your marketing people. Do the things that you can do best in your business and rely on other professionals to assist you. That's the way you're going to be most successful. That's the way you're going to avoid problems. And that's the way you're going to be able to find solutions to the problems that you're facing now.
Okay, thank you. Have a great day, everyone.
Take care. Bye.